Welcome to The Explainer. So picture this. Your company just landed a huge deal with an overseas partner. Everything is going great. Until, well, it isn't. All of a sudden, you're in a dispute. So whose rules do you follow? Whose courts do you even go to? That is exactly what we're breaking down today. How to navigate the incredible legal maze of international contracts.
Right, that's the big question, isn't it? When you sign a deal with a company in another country, you're not just bridging a cultural gap, you're trying to connect two completely different legal universes. So if things go south, do you end up in a courtroom in Tokyo or Toronto? Are they going to be using Japanese law or Canadian law? The answer to that question can literally make or break your entire case.
Okay, so to really get your head around this, you've got to know that most of the world runs on one of two legal operating systems. Think of it like Mac versus Windows. They kind of do the same job, but they are built on totally different philosophies, and they're called common law and civil law.
Let's start with the basic mindset. Common law, which you find in places like the US and the UK, basically says, hey, anything is allowed unless we've specifically passed a law against it. It's built from the ground up based on centuries of court decisions. But civil law, which is dominant across Europe and Asia, completely flips that around. It starts with a super detailed legal code and says nothing is allowed unless we've specifically permitted it. It's a much more top-down approach.
So what on earth does this mean for the piece of paper you actually have to sign? Well, in a common law country, you have to spell out everything, every little detail. The whole idea is to plan for every possible thing that could go wrong, because the law doesn't assume much. That's why those contracts can be 100 pages long. But in a civil law country, the legal code already provides this huge safety net of rules, so your contract just needs to fill in the blanks, and that's why they're often way, way shorter.
And trust me, these aren't just some academic points for a law school exam. They have massive real-world consequences for business. I mean, it affects everything down to how bankruptcy is handled. Common law systems try to save the business, while civil law often just moves to liquidate it. It even changes the power a judge has. In common law, a judge's ruling can actually become law, while in civil law, a judge's main job is just to apply the code that's already written. Okay, so keeping all that in mind, let's look at your actual contract. Tucked away in the back, you'll usually find two clauses that look like boring old legal jargon. But let me tell you, if a dispute ever kicks off, those two little clauses suddenly become the most important words on the entire page. They decide where you'll fight and what rules you'll be fighting with. First up is jurisdiction. The easiest way to think about this is choosing your home stadium. This is the clause that says, okay, if we have a problem, we're going to court in this city, in this country. So are you playing on your home turf in New York, or are you on their turf in Paris? This clause decides. And the second key piece of the puzzle is choice of law. So if jurisdiction picked the stadium, choice of law picks the official rulebook. It specifies exactly which country's laws are going to be used to settle the argument. And you know, it's possible to mix them up. You could actually be in a court in London, that's your jurisdiction, but be required to apply French law, that's your choice of law. Now, why is it so important to get these two aligned? Because mismatching them is a recipe for an absolute nightmare. Just imagine an English judge who's an expert in English law trying to decide a case based on Japanese contract law. It would be a mess. They'd have to hire incredibly expensive experts just to explain the basics, which adds a ton of cost and uncertainty. That's why the golden rule is almost always to align them. English courts, English law. Simple. But what if you don't want to fight in your partner's home court and they definitely don't want to fight in yours? I mean, that's a pretty common standoff, right? Well, this is where a really powerful alternative comes into play. International arbitration. It's all about finding a neutral ground. And just to be clear, this isn't some obscure legal trick. It is the absolute gold standard for global business. A huge survey in 2021 found that a staggering 90% of legal experts prefer arbitration for cross-border disputes. 90%. So what's all the fuss about? What makes it so popular? Well, let's put it head-to-head with a traditional court case. First off, arbitration is private. That's a huge deal if you'd rather not have your company's problems splashed all over the news. Second, you get to choose the decision maker. So instead of a random judge, you can pick an expert in your specific industry. Third, the decision is pretty much final, which means you avoid years and years of costly appeals. But honestly, the real superpower of arbitration is that last point right there, enforceability. That's right, enforceability. That's what gives arbitration its teeth. It's the magic ingredient that transforms a private decision into a judgment that's recognized all over the world. And it's all made possible by one single landmark international treaty. And this is the key number to remember. Over 170 countries, we're talking nearly every major economy on the planet, have signed what's called the New York Convention. This treaty is literally the foundation that modern international business disputes are built on. So, what does it actually do? It's brilliantly simple. It forces the court system in every single member country to recognize and enforce an arbitration award from any other member country. So, let's say you win an arbitration award in Singapore against a German company. You can take that piece of paper to a German court, and thanks to this treaty, they have to enforce it, just as if it were a ruling from their own judge. And this system is incredibly tough. A local court can't just say, you know what, we don't agree with this result, so we're not enforcing it. Nope. The only grounds to refuse are super narrow and are all about serious procedural problems, like if one side wasn't given a fair shot to present their case, or if the result would violate the country's most basic ideas of justice. The court can't retry the case. It just has to enforce the award. So here's the bottom line. Understanding if you're operating in a common law or civil law world, being smart about your jurisdiction, and knowing when to use arbitration, these are just tiny details for the legal department. This is core business strategy. And getting this stuff right is what makes sure your global handshake is backed by global force.